morning, everyone. Well, in the age of 2022, you wouldn't think that we would have computer issues at my end, but welcome to working from home. So apologies there. Sorry, Kath. So good morning or afternoon, everyone, wherever you may be joining us from. Thank you for taking some time out in your busy day to join our webinar, How Healthy is Your HR Compliance? For those who are not familiar with us, HR Assured is part of FCB. We help businesses to navigate around Australia and New Zealand's complex employment laws by providing a range of services and products to ensure businesses are workplace compliant. Next slide, please. So introducing our speakers today, we have Catherine Ajarau. Now I have had to practice that and I know that I just got it wrong again. And myself, Michelle Thompson. Catherine is a senior workplace relations specialist here at HR Assured. Catherine's passion is helping employers understand their obligations and helping to create a more positive and peaceful work environment. My role at HR Assured is a business development manager, and on a daily basis, I help businesses be their best by showing them ways they can elevate their HR and work health and safety functions. If you're not familiar with HR Assured, I'll just explain a little of the many benefits of partnering with us. You'll have access to our award-winning services, including our 24/7 telephone advisory service, otherwise known as TAS, you'll hear us refer to, comprehensive HR audit, our HR software, insurance and representation, work health and safety, and a library of legal resources. And throughout our webinar today, you may hear us refer to a few of these tools that our clients have access to. Work health and safety can often be put in the too hard basket, or I'll get to it, some say. Remember that you have a legal obligation to provide a safe workplace for your workers. We assist businesses to mitigate their risk by providing an end-to-end solution supporting your business and workers. A strong safety culture is very beneficial and positive to a great positive working environment. Okay, so on today's agenda, apologies, my screen again, we'll just scroll across to here. So today's agenda, we've got the importance of staying on top of your HR compliance, how you can protect your business, what happens if you get it wrong, and we're going to reveal the survey questions as well. And at the end of the session, we'll have some time to answer your questions. So throughout the webinar, you may have questions come to mind. Please either use the Q&A feature at the bottom of your screen, or for a more private conversation, please register for a complimentary consultation and we'll share the QR code during the presentation. So let's make a start. As you're aware, we put out a survey with key questions around HR compliance. These questions cover some of the most important aspects of HR compliance. Our first question revealed that 90% of those surveyed are aware of the modern award or awards that apply to their business. So it's great to see a high percentage of however, my only question would be, how often do people get it wrong? Awards are a key area that we focus on during the audit. So Kath, ensuring our clients are not exposed to underpayment or overpayment is very important. Kath, what are the risks if a business doesn't get it right or receives the wrong advice around their award classification prior to chatting with us?
Thanks, Michelle, and thanks for the introduction. So yeah, there's 121 modern awards, which is quite a lot. So it's really important that businesses are sure that they're using the correct one. Quite often we see clients through the audit process either unsure of what modern award applies or completely using the incorrect one. And more often than not, when a modern award is used, but it's actually incorrect, the client has received advice from someone who may not be a qualified HR specialist, but has other areas of expertise within the business, such as the company accountant or the financial advisor. So modern awards, they stipulate minimum employee entitlements, and some of those entitlements will carry across all modern awards. So for example, things like annual leave loading might carry across all of them, but otherwise there are different entitlements that'll vary between the awards. So for example, overtime rates, when overtime actually will kick in, weekend penalty rates, public holiday penalty rates, things like that. They all differ depending on the award. So it's really important that we're paying our employees under the correct one. We want to do so we can avoid underpayments, but also overpayments. So obviously underpayments because we want to mitigate that risk of an employee potentially making an underpayment claim. But there's also a fair bit of brand damage that can come with that if the underpayment is picked up on by the media. So we want to avoid that at all costs. But we also want to avoid underpayments so that the business is obviously not out of pocket. And recouping these amounts is usually quite difficult, if not impossible at times. We've got two different types of awards. So you've got industry awards, which may cover an entire industry. So for example, the general retail industry award will usually cover all of your retail staff. Or you've got occupational awards, which will cover specific jobs. So for example, people in more administrative or clerical roles will come under the Clerks Award. A top tip for businesses is to keep in mind that not all employees will be covered under a modern award. Some of them will actually be award free. So that's really important to keep in mind. Once again, for that overpayment risk there, we don't want to be paying someone something that they're not actually entitled to. HR Assured can help by undertaking a compliance audit to identify the scope of the business, but also the employees, and see what awards, if any, you guys will fall under. We also provide 24/7 advice on award coverage through TAS, and it's one of our biggest topics, I would say.
Okay, thanks, Kath. And Kath referred to TAS, so that's our telephone advisory service, just reminding you, our cheap way of saying it. So look, again, it's great to see the results of the next part of the survey. We had 91% of those surveyed issuing their employees with a written contract, which is brilliant. But although it is nice to get a pat on the back, we are here to discuss the common pitfalls when you're not issuing a contract or you've got a contract which has been poorly written. So believe it or not, we actually could run an entire webinar on this topic. It's likely to raise a few questions. So again, please utilise the Q&A function or the complimentary consultation. Kath, most joining us on the webinar have contracts in place with their employees by what we can see there. But can you tell us the most common pitfalls and what you need to address, obviously, when you're reviewing a contract?
Yeah, so I guess the most common pitfalls we see are probably people not having a contract in place at all because historically they've never had them or they just don't think it's necessary. So yeah, some businesses don't have them at all, and some may have them in place, but they're not actually effective in protecting the interests that the company is seeking to protect. So having a contract in place is one thing, having a good one in place that's actually protecting the business needs is another. A really common thing we see is clauses that are perhaps better suited for company policies or in employee handbooks, things like that, but instead they're put into employment contracts, and as such, they're a bit out of place, sometimes may not be as enforceable and things like that. It's really important to note that not everything within the employment relations realm is actually enforceable without a written contract or something in place. So for example, restraint periods. We need to have a restraint period written within a mutually agreed upon contract that the employee has physically signed themselves. So a really common thing we see in TAS as well is companies trying to enforce restraints after an employee's specific employment has ended, but they don't actually have any restraint clauses in the contract. And in that case, something like that is just not enforceable, even though it is quite standard in an industry to have things like that. Top tip is that some clauses are more practically important than others, and some clients like to use short form contracts instead. So if you think that your employees are going to benefit from having a shorter contract in place, something that they're probably going to read and really take in a bit more, short form contracts are great, and we can take some clauses out that are less important than others. We can help by reviewing contracts currently in place during your compliance audit, or we can help you generate new contracts through the HRA cloud and through our telephone service.
Thanks, Kath. And look, I find that really interesting. And over the years of speaking with businesses around the topics of contracts, yep, you're absolutely right. The restraint of trade, too often it's been left out. So you really need that eye of the professional over the contract to understand what you are and aren't missing, especially for particular roles. So thanks for running us through that. Now, the next survey result, I guess these results here aren't surprising. Only 57% of those surveyed show the casual loading as a separate identifiable amount on their employee payslip. So some would assume that if your employee status shows as casual on their payslip, that's all you need. So I guess, Kath, why should we show the casual loading as a separate amount on the payslip? And is it law or is it just best practice? Thank you.
Yeah, so this is probably one of the biggest compliance issues we see during audits. I'm actually pretty impressed with this score because more often than not, companies are not aware that they should be doing this. So companies are usually aware that they have to pay casual employees a casual loading, which is obviously in lieu of permanent employees' entitlements. But so many are not aware that this must be a separately identifiable amount on the pay slip. So we can't just have that, $27 per hour. It should say somewhere this $27 is inclusive of X, Y, and Z loadings. It's not a best practice thing. It's more so a requirement. So it's something that all businesses must do to avoid exposing themselves to risk of contravening the Fair Work regulations. And honestly, once you are aware that you're not doing this correctly, it's such an easy fix. You can just pop it into your pay slips, the template pay slips, and get that going from that day forward. Top tip is that there are pay guides from the Fair Work Ombudsman for each modern award. Sometimes they can be a little bit confusing or difficult to read or follow. So HR Assured also creates pay guides for the more popular and the more commonly used modern awards. And we just kind of simplify them so that they're easier to use and you can get what you need ASAP. We can also help by reviewing employee pay slips, whether that be during our initial compliance audit or through TAS.
Great. Okay. Right, with the next question, 33% of those surveyed aren't aware of the changes to the casual conversion legislation and the steps that must be undertaken to comply with this new legislation. So I guess, look, this number is a little concerning given we're nearly 6 months past the grace period. That was a grace period date given to comply with that. We do have, I've had a look at who's on the call, business sizes. So we've got varying sizes of businesses. Look, even if you are a small business, it may not apply to you now, but if you have plans to grow, then you'll need to know this for the future once you're over 15 employees. So please help us to understand this side, Kath.
Yeah, totally agree, Michelle. Even when I have small business employers coming through the audit process, I always like to pop in these casual conversion legislation changes to their audit report, just so they can be aware, like you said, if they do grow and they need to know that in the future. It's a really massive change to the employment relations space last year. Because it shifted the onus from essentially being an employee's entitlement to becoming an employer's legal obligation to offer that. So it applies to large businesses only if you've got 15 or more employees, and it's relevant for those casual employees that have at least 12 months continuous service with the company and have been regular and systematic for at least the last 6 months of that 12-month period. Employers are also now obliged to provide a copy of the Casual Employment Information Statement, or the CEIS, and they have to provide that to all casual employees upon commencement of their employment. And basically what that statement is it just outlines to the casuals what their entitlements are, and it outlines to them what their entitlements are in regards to casual conversion. So a top tip, there are actually a few very specific and intricate circumstances where casual conversion may not actually be required, even for a large business with more than 15 employees. So it's really important that businesses are aware of what circumstances may apply to them that could potentially alter their obligations. We can help by providing step-by-step advice through TAS to make sure that you're following the right process and meeting your obligations, but we also have written process flows and checklists on the HRA cloud for you to follow.
Excellent, thanks, Kath. So next we looked at working from home. So with today's environment, working from home is becoming very, very regular in the norm, I guess. With 65% of those surveyed not having an up-to-date working from home policy or risk assessment completed, we'll take a look at why this is important, especially under WHS laws. So at HR Assured, we actually provide our clients with an up-to-date working from home policy things like ergonomics checklist, and help you assess a risk with the employee and help you to mitigate other risks. And these could be things such as mental health. And the reason that I say that is it's well acknowledged that there's now a blurred line from when the workday commences and finishes. And we're hearing of burnout and mental health issues developing. So you can see that working from home isn't just a simple step. We really need to take into account quite a few different factors in some cases. And I will say just at this point as well, it really does blend into the culture of the business, and you can have a great working from home setup with your employees and really promote some of those healthy working from home habits as well through your people culture. So we suggest this is approached, as I say, with a good foundation in place. So thanks, Kath, if you can take us through this.
Like casual conversion, I guess, this was another really big change in the employment relations space, especially as we're learning to adapt to that new COVID-19 norm and that working from home office hybrid lifestyle. So essentially, there's been some significant and pretty serious and sensitive cases recently where the employer has actually been found liable for an illness or an injury suffered by an employee when they're working from home because an adequate risk assessment was not actually conducted before they did that. So employer obligations under work health and safety legislation is to do whatever is reasonably practicable to ensure that employees are healthy and safe in the workplace. It's a new blurred line now because there's a new definition of workplace since COVID-19 to include any location in which an employee is required to perform their work duties. So that could be on, the employer's premises in the office, the standard, or it could be at home, could be at a client's site or personal accommodation, vehicle, the list goes on. So it really is something that we've got to get onto ASAP and make sure that we're complying with, because the opportunities here are endless, really, to define where that employee's workplace is. Top tip is to undertake risk assessments, really. They're a really easy way and relatively simple way to make sure that you're satisfying your WHS obligations to your employees. So like Michelle said, getting employees to complete a ergonomics checklist or a risk assessment form before they're working from home to say, yes, okay, I'm sitting on this kind of chair. The screen is this far away from my face. No, I'm, not hurting my back, things like that. Simple as that, to have an employee sign off on that, store it on your system, and then that way you've undertaken your obligations. We can help because we provide a WHS audit, which identifies any risks and gaps in things like that. And then we can then help you to implement the policies and procedures that are needed, as well as provide ongoing advice through TAS, of course. Our important WHS tools, such as incident reporting or return to work checklists, they're super easy to use and they're on the HRA cloud, and they also come with process flows that outlines step by step what you need to do and what you need to undertake.
Brilliant. Thank you, Kath. The results of the next survey show that only 9%, if we can have the next slide, let me just check, yep, 9% are not providing pay slips to their employees within one working day of being paid. So Kath, if you can take us through the obligations of any risk associated when not complying with this, that'd be great.
I'm pleased to hear about the results of this survey question too. It's another one that in the compliance audit, we usually do see employers usually quite compliant. So as per the Fair Work Act, section 536, we have to provide pay slips to employees within one working day of them being paid and receiving that payment. So this is even if the employee is on some type of leave. So if they're away on sick leave or they're on a holiday and they're on annual leave, we still have to provide that pay slip within one working day. There's also a reverse onus of proof for alleged contraventions of this section, meaning rather than the employee having to prove that something has taken place, the onus is on the employer to disprove, which automatically becomes a little bit more difficult, a higher threshold to meet, and obviously a bit more of a hassle for the company to have to deal with. Top tip is something that a lot of people do anyway, but is to set up your payroll system to automatically send out pay slips within one working day of that employee's pay being processed. So that can be as simple as setting it up from the get-go, and then you don't have to think about it at all forever. We can help by reviewing your pay slips through the audit and the telephone advisory service, but we also can because we provide integration with payroll in our HRA cloud.
Okay, so the next topic, we had 86% of businesses that were surveyed do actually keep record of issuing the Fair Work Information Statement. So if you're the remaining 14% there and you don't know what this is, it is an obligation that you need to be across if you're employing people. So we see a lot of businesses that either have no record keeping system in place or they can be very relaxed with this. Kath will take us through the importance of handing out the Fair Work Information Statement and keeping record as a part of your induction. But just before we dive in, consider electronic onboarding and record keeping for your business because it's good in a sense that it keeps your time, date and stamp. We know that that's gone out to an employee and we can prove that if we're asked. So over to you, Kath.
I'm actually quite surprised by these results, to be honest. It's really, really common that we see employers either not issuing the statement at all, not even being aware of it, or issuing it and not actually taking record of issuing it. So I'm quite pleasantly surprised by this, that only 14% said no, they weren't aware. But basically, what is the Fair Work Information Statement? It's a statement much like that casual employee one, which basically just outlines all an employee's entitlements at work, but also their entitlements under the National Employment Standards, or NES for short, we say. And the NES will apply to pretty much all employees in Australia, except for, once again, those really specific scenarios where it may not. But the Fair Work Information Statement is really important because it gives employees that opportunity to see what they're entitled to at work and how their employment should go. Employers have to keep a record of issuing the statement to all their employees to be compliant with the NES. And a top tip is to issue the Fair Work Information Statement and the Casual Employment Information Statement at the same time to those employees that are eligible. Obviously, you're not going to be issuing the casual statement to full-timers or part-timers. And then that way you're ensuring compliance and you're knocking out two birds with one stone, and you're also record keeping for both of them at the same time. We can help with this by allowing for automated record keeping in the HRA cloud, which I'll actually go into a little bit further in. I think it may be the next question, Michelle.
Okay, great. And also, I'll just say with the Fair Work Information Statement as well, if you are bringing on new employees down the track, just keep in mind that it does get updated. Is it annually, Kath? Yep.
Not annually, but here and there.
Here and there. Okay. See, that's why I asked the expert. Okay, so the next question, it's great to see that 98% of those surveyed are keeping records of a period for the last 7 years. And sorry, that's the employment records. And this record, I mean, obviously you can record it a number of different ways. We often see that people are still keeping paper records in smaller business. Obviously larger businesses have got different ways of electronically recording. But Kath, if you can run us through the types of employment records that must be kept and also the types, your best tip for the best types of recording those would be great.
Yeah, so employers have to hold on to employment records, including time and wages records, for 7 years. And I guess the basis for this is that in case there's an underpayment claim. So if there is an underpayment claim, the employer or Fair Work may need to rely on those records to assess the validity of the claim and see how much the employee is due. Keep in mind that when there is an underpayment, we have an obligation to back pay up to 6 years. So it's really important that we have those records available to us. And if they're not, there's pretty hefty fines and penalties that can be imposed by a Fair Work inspector. So the records themselves, they should be accessible to a Fair Work inspector if they are seeking it. They should be legible and they should be written in English. They can't be changed unless the change is done to fix an error, and they can't be falsified, they can't be misleading. They should have the exact information on there. So we have to have time and wages records, and that should include things like hours of work of employees, any type of leave that they've taken, what their leave balances are, but also things surrounding their, superannuation and guarantees of their annual earnings. So that could be superannuation things such as what are the superannuation payments that have been made, but also where is the employee's superannuation form, and things like that. So on top of your time and wages records, you should also keep details like the employee's start date, their commencement with the company, their type of employment, so full-time, part-time or casual, and whether they're permanent or on something like a fixed term temporary arrangement. A lot of employers, like you said, Michelle, like to do it the old-fashioned way of keeping physical records locked up somewhere safe. And honestly, that is totally fine, as long as they are safe and secure and you're complying with everything else I just said. Yeah, a lot of people just like to do that and have it locked up with a lock and key, and they feel more comfortable doing it that way. But as technology evolves more and more people are doing record keeping and things like that, they're preferring to do it electronically, having it all in the same place. Don't have to worry about things getting damaged or fading over time or things like that. My top tip is that if you're not sure whether to keep something, just keep it anyway. I do tell people through TAS quite a lot if they're saying, I'm not sure whether to keep this or whether to keep that. Best point of call is always to just hold on to it just in case. We can help because we do automated record keeping on the HRA cloud. And of course, we have ongoing advice through TAS about your obligations in regards to this.
Kath, I did just see a question pop up on my screen quickly, and that was, do the records need to be kept for a period of 7 years after the employee leaves? I think I've just been looking for it, but I can't find it.
Yeah, so they have to be kept for 7 years regardless of what happens to the employee. So if employment ends or they're made redundant, terminated, anything like that, we have to hold on to them. So like I said, it can be quite a lot of record keeping, which is why a lot of people are preferring to do it electronically now, so they're not holding on to stacks and stacks of documents. But yeah, 7 years regardless of the circumstances surrounding it.
Okay, great. I just managed to sneak that one in while I was on that topic. All right, so the next section we looked at the employee handbook. So who's got an up-to-date handbook? So this would be a topic that you want to grab a quick coffee for, because 53% of those surveyed do not have an up-to-date employee handbook. So I think there'll be some serious note-taking here, but Kath, I'm also assuming you're going to have some good information to give us around this and how we might insert some simple policies. But in place at the moment, somebody might have a simple code of conduct, for example, but should we be considering how we put all of those policies into an employee handbook, etc.? So I'll hand that over to you.
Yeah, so this is actually another really common compliance issue we see with clients. And it also almost feeds directly back into what I was saying before about not being able to enforce things unless they're in writing. So employee handbook is considered an important document which communicates an employee's rights, entitlements, but also the company's policies and corporate values. So the handbook itself, it doesn't really dictate it doesn't dictate alone what the employee's entitlements are, but it can also dictate how they're expected to behave at work and what are the employer's processes and procedures that they must be following when they are at work. So there should be separate policies within an employee handbook that are relevant to your business, whatever that may be. And if you want to implement, let's say, for example, drug and alcohol testing or something like that, or rules surrounding how employees engage with each other over social media, equal employment opportunity, all of those kinds of things, they're best suited in a handbook. We do often see, like I said earlier, some things in employment contracts that are better suited for a handbook. And look, it's not the end of the world if things are in the wrong spot, but it just makes your admin a little bit cleaner and it takes away that administrative burden if they are in the right spot. Like I said, keep in mind that there are things that just cannot be enforced at all unless we have it in writing somewhere. So back to that example of drug and alcohol testing, I guess. If we don't have a drug and alcohol testing policy in place and we think that an employee has rocked up to work intoxicated or something like that, we may not actually have a right to test them and then take further disciplinary action because we obviously don't have any evidence. So really, really important that we have the correct policies and procedures in place, not only to communicate to employees what their entitlements are and how they should behave, but to really protect the company and give the company a basis or grounds for conducting disciplinary meetings if that's what's needed. Top tip is to not only implement a handbook, but schedule regular training for employees so they can understand what's required of them as per the company policies. So we do see quite often that we are providing a handbook to a client and they've provided it to their employees, and their employees have come back and said, yes, tick, I have read it, I understand. And then 6 months down the track, there is a massive breach of the policies and the employee comes back and says, well, actually, I never read it. How was I meant to be aware of what was in there if such a lengthy document and it's complex? I didn't know what I was supposed to be doing. And obviously it sounds like a rough defense, but you'd be surprised at how often it holds up, that Fair Work. So really important that we're doing training and things like that for employees as well, rather than simply just handing them the document and saying, read this. We can help by identifying what policies are missing throughout the compliance audit, but also with creating the documents themselves through TAS and the HRA cloud.
Excellent. Okay. Now, next we have another very interesting question. So 54% of those surveyed who pay their employees an annualised salary or above wage do not have an offset clause in their employment contract. So Kath, understanding that issues can arise such as underpayment if this is not included in the contract or the contract is not written correctly, can you please help us to understand the complexities and how best to set up a contract when paying an annualised salary or above award wage?
Yeah, so this is another one that feeds into that overpayment ones. And this is super important because I know it's really popular. A lot of the time, employers will pay an annualized salary that's inclusive of all of an employee's entitlements. So for those that may not know what an annualized salary is, it's essentially rather than paying an hourly rate and then, you know, you've worked 7 hours on a Saturday, that's 7 hours of Saturday rates, 2 hours of overtime rates, you know, 5 hours of late night trading, whatever it is. We incorporate all of that into an annualized salary and we say, okay, we have calculated what you're compensated for, and that is all within your salary. That's all combined in there. So a lot of the time employers like to pay an annualized salary that's inclusive of all of those entitlements, but a lot of employers don't actually have an offset clause in writing, meaning that if we have an annualized salary and no offset clause in writing, an employee is technically entitled to all of those additional entitlements, which is already incorporated into that really high salary. So if we're intending to pay someone on an over award or over enterprise agreement basis, we should really ensure that our contracts of employment are making it super, super clear that the over award payment is directed towards satisfying all of those entitlements that an employee would otherwise receive. I shouldn't say otherwise because they are still receiving it. It's just not essentially coming out as a separate figure. It's all incorporated into the one. This is super important now as well in light of a recent ruling that the standard offset clause in the modern awards will be removed. So look, that clause was never actually intended to provide a means of automatically annualizing entitlements under the award, but over the years it had often been used in that way. So that decision is really important, and it's a really important reminder to employers that that clause itself can't be relied upon, and we should be offsetting things in writing elsewhere. It's also advisable to include provisions within the employment contract that state that the rate will be reviewed periodically to take into account any changes in the modern award if the base rate is going up, but also if there's changes in superannuation. So we do have a lot of clients that try to use the superannuation increases to essentially decrease an employee's wages, but it remains the same salary. We can't do that. So it's really important that we're reviewing things periodically to take into account those changes to legislation. Top tip is that offset clauses should be drafted really tightly, really securely to avoid any ambiguity and any room for a dispute. And they're best suited within an employee's contract of employment. Same goes if we put it in a policy or a handbook, it may not be as enforceable as if it's in the employment contract. We can help by drafting one of those clauses through TAS, or we have a standard template that is available on our HRA cloud.
Thank you, Kath. Okay, so now we get to some questions. And look, I can see you guys have popped some questions into our Q&A box during the webinar. So I've just been having a little look over a few of them now. We'll try to get to as many as we can, but I'm conscious of the time, and apologies once again for our webinar starting slightly late due to technical errors. But I'll run the first question by you, Kath, and then I'm just going to get another one while I'm doing this. So what do I do if there's a slackness of trade during COVID?
Great question. We get this all the time. I'm sure a lot of companies have been facing this since the beginning of the pandemic. So if we've got a slackness of trade, or you're no longer requiring an employee's job to be performed by anyone, not just that employee. So just to be clear, this doesn't apply if we don't like the employee, or their performance is poor, or there's misconduct. If we don't actually require that job to be performed by anyone because there's either operational or structural changes to the business, or a slackness of trade due to COVID, or whatever the slackness is due to, redundancy is the way to go. So it would be a redundancy process. Managing a redundancy process, though, is quite difficult because it's such a complex and intricate process. So you really want to make sure you're doing it correctly to avoid an unfair dismissal or a general protections claim. So yeah, really important that employers are treading carefully when they're undergoing a redundancy.
Oh, thank you, Kath. Okay, I hope that helped with that answer, or with that question, sorry. The next question that I'm going to run by you is, how often should I do salary reviews?
Okay, yeah. I mean, there's no legislative time period. You know, there's nothing in writing that says you must do a salary review this often. And it's not even an obligation, to be honest, to actually do a salary review. But I like to say, as a general rule of thumb, to do salary reviews annually, whether that be at the start of every financial year, because that's usually when there's an update to the Modern Awards, or on an employee's anniversary date. So that can help you keep track of it. So you can do them more or less frequently than that if you want. But I think having set timeframes like that, either financial year or anniversary date, having a set timeframe like that in place creates a nice routine for the company. And it means that you're probably less likely to miss that.
Okay, fantastic. Thank you, Kath. I just actually had one around the handbook. Oh, there it is. Sorry, it's in the chat. Just a quick question, and I will wrap up, everybody, because I'm conscious of time, but does it need to be a handbook, or can we not have an intranet site with policies, procedures and forms?
Yeah, we can have an intranet, that's fine. I guess handbook is just a fancy way of saying it, because rather than it being one individual policy, it's a bunch of different policies about a bunch of different things that are all put into a handbook, as we like to call it. But that being said, you can have separate policies and issue them as separate documents on an intranet as well. So if you wanted to say, okay, here's our bullying policy, here's our social media policy, here's our leave policy, etc., that's totally fine. We just always like to put it into one document, get it all in there together, can issue it over an intranet, which is totally fine. And we can do that through the HRA cloud, issue it out to employees, and they have this thing called employee self-service. So they can log on and actually read that, sign it off and tick it as acknowledged, and that'll give you an email notification that it's all signed. Or you can do it the old school way of giving them a physical document and getting them to physically sign off on it.
Thank you, Kath. Okay, and look, I'm sorry that we can't get to all the questions. Nearly all of the questions in our Q&A have a name attached to them, so we will try to reach out to you and just answer those questions. Alternatively, Annette's just popped up on the screen for us, so we have the QR code there that you can scan, and that'll come straight through to us for a complimentary consultation. We can answer those questions that we can see there that you have. And also just any questions around HR, work health and safety, we can help your business with. So once again, thank you all for your time today, and we really hope you enjoyed the session. And we would love you to follow us on any of our socials. We post some really informative articles and tips. So if that would help anybody, LinkedIn, all the rest of it, great information. But please enjoy your day. We look forward to having you join us at the next session. And thanks, Kath, for helping everyone to understand HR compliance for their business. Thank you.
No, thank you, Michelle. And thanks everyone for joining us today.